This video is for all U.S. citizen parents or green card holder parents who want to file for their children. This just happened. I just got off a consultation, and so while it's fresh in my mind, I wanted to go over it. If you are a U.S. citizen parent and you want to bring your son or daughter here to live with you in the United States, son or daughter who's over 21, when you file for them and they are not married, so if you are a U.S. citizen parent or a green card holder parent filing for your son or daughter who's over 21, the wait time right now is about 10 years. I think you know that. You file, you get in line, you wait 10 years. The problem is, and this happens very often while you're waiting, is if during those 10 years that you're waiting and your son and daughter are waiting abroad, they get married, it becomes a completely different category. So for U.S. citizen parents, if you're filing for a son or daughter overseas and you're waiting for 10 years and your son or daughter gets married in the meantime, they are now a different category. They are an F3 category. They are married. They're son or daughter who are married of a U.S. citizen, and the wait time is increased by about 5 years. So this is what happened. My client just called. They said, I filed in 2013 for my daughter, and I just got a letter saying it's time to do the consular processing. It's time for her to come, but she's already married. Let's do the case. And unfortunately, I had to tell her that we can't do the case because she's now married and she's in a different category. You have to let immigration know that this happened, because if she was to come to an interview and tell them that she's married, they would deny the application and she would have wasted all this time. So you have to let immigration know as soon as your son or daughter gets married, so they will reclassify the petition. And for green card holder parents, if your son or daughter gets married while you filed for them, they cannot come. There is no such category as a green card holder parent filing for their married children. Green card holder parents can only file for their sons or daughters if they are unmarried. So if they get married, you have to become a U.S. citizen to file for them. This is very important because it was heartbreaking to let these people know that they actually are going to have to wait another 5 years or so before their daughter can come. So, keep that in mind. Do yourself a favor.